Hi, this is Darin Mangum again, your PPM attorney. Just posting another video on some common questions that I get all the time from clients and prospective clients regarding various issues that always come up. One thing I wanted to talk about today was the question about what if my offering for whatever reason doesn't fit within the 506B or 506C exemptions. I mean, those are, like we talked about in the last video, some of the most common exemptions, but those are, of course, safe harbors that the SEC has created. Are those the only available exemptions? Like what, for example, a common question is, well, what happens if I have maybe 36 or 37 non-accredited investors in my deal? Or let's say for whatever reason, I'm technically a bad boy, or I've had some sort of infraction in the past, and maybe 506B or 506C is unavailable to me. What can I do? You certainly want to try to qualify for the safe harbor exemptions if you can, but if for some reason you can't, there is a fallback exemption to 506B. 506C, there is no real fallback. There is no statutory fallback exemption to rely upon. 506B, on the other hand, let's say for some reason you're not fitting. Let's say you didn't file your Form D. Let's say, some reason why 506B is not available. And again, we're talking about the private offering exemption. There is still Section 4A2 of the Securities Act. Now, 4A2 it wasn't created by the SEC, it was created by Congress. It's a statutory exemption. Again, it's a federal exemption that provides for an exemption for private offerings of securities. Now, Congress didn't define what that meant, and so later on the courts over time have defined what that meant. And basically, in a nutshell, and it's very fact specific to your particular offering, but basically you could still technically qualify for exemption under 4A2 of the Securities Act if, number one, your offerees, you have a pre-existing relationship with them. In other words, you didn't go out and publicly solicit or advertise for the offering. Number two, are those investors sophisticated? Do they have the wherewithal or knowledge regarding the offering? And number three, did you provide them with disclosure, like through a PPM, of all the material facts regarding your business, or did they have access to that type of information? Now, if all those are true, then yeah, you may still be able to rely upon again Section 4A2 on the federal level. Now, that doesn't mean you're in the clear on the state level. You've got to then look at the various state exemptions, and most states have private offering exemptions that cover securities transactions. Usually it's a limited amount of money to a limited number of investors, like 10 or fewer, less than $1 million within a 12-month period, that kind of thing. And so, the nice thing about fitting within the safe harbor exemptions is that you don't have to then look at all these various state exemptions, because again, they're federally covered securities. But again, in the event you fall outside of that safe harbor, or you're not able to rely upon the 506B or 506C, then again, 506C, there is no fallback. 506B, if it is a private offering, then you do have a Section 4A2 potential fallback position. Anyway, happy to answer any more questions you have about this issue. You can just give me a call or shoot me an email. I'd be happy to address those. Anyway, hopefully this is helpful, and again, I'll be posting more videos, so stay tuned. Thank you.